People v. William Rubert, file 2020-5929FH for sentencing on resisting obstructing, a 2-year maximum with a guidelines range of 0 to 17. After a delay of sentence, counsel, you want to state your appearances for the record?
Melissa Goodrich, Wayne County Prosecutor.
No, not yet for Mr. Rubert.
All right. And have you had a chance to review the report and recommendations?
We have to just.
Any additions, corrections, or scoring challenges?
None.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
And then you want to say on behalf of Mr. Rubert?
Of course. For Mr. Rubert, Judge, what I will say on his behalf is that he's been a very pleasant person to work with. I know that we always have an uphill battle from the defense side when there's such a long absconsion period. I'm sure the court wants to know what Mr. Rubert was doing.
Other than committing a felony in Florida.
Right. So part of what I wanted to bring up is that, right, was that he did have that probation sentence out of Florida. It does appear to me that he successfully completed it. I don't at least see anything to the contrary. Normally there is a pretty clear demarcation that, someone was unsuccessful or terminated unsuccessfully, et cetera, et cetera. I don't see that, so I have to assume that he's completed successfully. I do think that's a positive, not the new criminal behavior, but the fact that he completed community supervision is and should be considered a positive by this court. What I would also let the court know, and I think the PSI alludes to this a little bit, is that Mr. Rubert was obviously struggling at the time that he was placed on this original probation sentence, struggling with both drugs and alcohol, struggling with figuring out how to parent a child, figuring out how to be a partner to another person, another human being that's also struggling with drugs and alcohol. Unfortunately, Mr. Rubert made a decision to leave Michigan. Unfortunate for him legally, I think very fortunate for him personally, because as he and I have talked about, and his mother has written a letter to me at this point, everyone is very convinced that if he would have stayed here, he would be dead. And so I'm thankful that he is not dead and that he is alive and before us and here to be sentenced. Judge, he did lose his partner December 23, and I think to her addiction. And I think, if anything, that was a real wake-up call. I know that's sort of a cliche thing to say, but for him, I think it's true that opened his eyes and affirmed his path going forward. And I hope he stays on this path. I think that he's a very nice guy. I think that he has a lot of positive things going for him in light of some of the negative things that are in that PSI. I think this court should sentence him as though the delay never occurred. So I think the court has to wrestle with, well, what would the court have sentenced him to had we not gone through all this time? And so I guess that's my question for the court is what is fair and under these circumstances. I would posit to the court that 60 to 90 days would have potentially been a fair resolution at the start. And so that's what we would ask for now, understanding the recommendation. But nonetheless, Mr. Rubert is he's here and he's accountable for his actions. He knows that he's made mistakes and he wants to move forward and do better. Thank you, Judge.
Thank you, Mr. Knight. Mr. Rubert, you don't have to make a statement, but it is allowed. Is there anything you want to tell me? People?
Oh, yes. Thank you, Your Honor. The defendant is 35 years old. He has no prior felonies and 5 misdemeanors. He was given a second chance initially on this case by being offered a delay. He chose not to take that second chance and instead made the decision to leave his probationary terms, commit another felony, and did not return on his own. He also was granted another gift by not being charged with absconding, which would have been warranted in this case. I ask that the court follow the PSI recommendations for 6 months.
Thank you, Mr. Rubert. If you want to please stand for the court sentence. This is, I know your attorney has given I mean, I don't take them to be excuses at all, and they weren't offered for as such, but as explanations for a period when you were making bad decisions, and he's, set forth some explanatory reasons for what was going on in your life for that, which it's just unfortunate too, because, the police are called out to your residence for what would have been a misdemeanor case. So let's back up to that night. There's a domestic incident, police go out there, and then you think you're in Shawshank Redemption or something. You're running through the woods and they're after you with a dog, and now you got a felony case for an RNO. And then you get a delay of sentence, or you don't go to jail for it. And you get a chance to have the felony go away. And then you take off. You tell your probation officer, gee, being on supervision sucks. Well, yeah. I know that. But nobody just grabbed you at random out of society and said, guess what? You get to be under the supervision of the Department of Corrections probation parole agent. You did that. And you decided that wasn't a plan that you liked, so then you flee to Florida. And then you get in more trouble down there. And then you don't, I don't know why. I mean, now it's 4 years later and you're back dealing with this case, which again, started as a misdemeanor case. And you've just made it grow and grow and grow. Where we have somebody on a delay and they pretty much thumb their nose to supervision, take off, go to another state and commit crimes, or at least a crime. The prosecutor's right, they could have charged you with absconding a felony, which is a 4-year felony, even more than what you have right now. And they have not done that. And there's good reasons not to do that under these circumstances. So I'm not faulting that at all. But I think all that to be said, that the recommendation from the Department of Corrections is I think a fair one, and it's measured under the circumstances that's what's going to happen for you here. I hope you have turned some things around, and that this is a case that shouldn't have been a felony to begin with. So I certainly hope we don't see you back in felony court here. But again, that's going to be up to you. So I will sentence you. The fines and costs will be as assessed in the previous hearing, in the amount of any unpaid balance, and I'll order that you serve 6 months in the Sheboygan County Jail, credit for 51 days served. That is within the advisory guidelines, although they are an intermediate sanction. There's reasonable grounds for incarceration in that Mr. Rupert absconded from supervision. You can file an application to appeal if you wish to the Court of Appeals. If you wanted a lawyer, I'd give you one, but you have to ask me within 6 months. So we're going to hand you some appeal paperwork, ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal. But you're not going to be on probation with me anymore. Once you're done with your time, you're done with your time. Then contact the court to set up payment plan on what you owe. And if you make reasonable efforts there, we won't have any contempt problems. And hopefully you and I don't have to see each other in the courtroom. Okay? So good luck to you.
Thank you.
I see Mr. Wing and Mr. Tony. Good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we'll begin our afternoon docket with an arraignment and a show cause in People v. Jacob Kiefer. It's file 24-6934FH. Counsel, please state your appearances.
Mr. Goodrich, Sheboygan County Prosecutor.
Thank you, Your Honor. Good afternoon. Brian Quinn, on behalf of Jacob Kiefer, is that counsel table to my right.
Okay, and for purposes of arraignment, have you had a chance to review the charging document with Mr. Kiefer?
Yes, Your Honor. In this case, we did file a written waiver of the arraignment, entering a plea of not guilty that has my client.
Okay, so we'll enter a plea of not guilty. And forensic center referral requested?
No, sir.
Estimated length of trial?
I would estimate 2 days.
Okay. Let's schedule this for a docket call January 28th at 1 o'clock.
January 20th, 1 o'clock?
Yes.
Yes, Your Honor.
We'll actually be holding that, I believe, in the district courtroom because we'll be January and February will be down for renovations in the circuit courtroom.
I would have to say long overdue.
All right, and then we also have a show cause on the docket. Mr. Kiefer, it's alleged that you are in contempt of court for violating the conditions of your bond by submitting several diluted drug samples, urine samples for drug testing. You have the right to have a hearing on those allegations, where they would need to be established beyond a reasonable doubt. The right to the assistance of your lawyer at any such hearing and to present evidence in your own defense, cross-examining the evidence presented against you. If I find you to be in contempt, I could jail you for up to 93 days and or fine you up to $7,500. Also, if you are not complying with the conditions of your bond, I can revoke that bond. So, Mr. Clayton, do you know how Mr. Kiefer wishes to proceed on that?
Yes, Your Honor, we'd ask to schedule for a hearing. I received the allegations, but some supporting documentation, but not all.
Okay, we'll schedule that for a bond violation hearing on the same date and time. I do want to hear from the parties whether I should consider revoking Mr. Kiefer's bond at this time, given the sheer number of dilutes that he's submitting. Mr. King.
Yeah, and I was going through this today, the last dilute that I see, I know we briefly dealt with this in district court in front of Judge Ekdahl. And I only have, I guess, with us all one missed, not forgiven call back in early to mid part of November. But I'm not, as the court says, there's a large number of dilutes. I'm only seeing even an allegation of 3 since on bond.
Yeah, that was on the show cause. I mean, I'm just looking at, we've gotten still more testing just, as they come in, and they've frankly all been dilute. The ones on the show cause are November 5th, November 7th. Since then, all the tests have been dilute that he submitted, November 12, 15, 18, 22, and 26. And in the district court, he had, looks like 5 dilutes. He had one that was not dilute. He had 5 dilutes. Whatever happened in the district court? Was there any sanction imposed?
What happened was when we waived the preliminary examination, Judge Ekdahl moved all of that up here.
Oh, okay. And I didn't deal with those, I don't think, so. Okay.
No, they were just never dealt with.
Okay. All right, well.
They are based on the continuing dilute test all the way back to, I believe the first one was September 3rd, and now we're in December. His criminal history is 8 felonies and 2 misdemeanors, all involving substance abuse. The people are concerned about public safety issues.
Yeah, Mr. Kiefer, you must think me a fool. Your bond is revoked. You're remanded to the custody of the sheriff. I'll see you on January 28th.
Sir, I'm not masking anything. I don't have anything to mask going on.
That's the order of the court.
I'm trying to turn my life around.
That's the order of the court. We're done. I'll see you on January 28th, sir. Go with the deputy immediately. If you want to go with him, keep it up.
I'm trying to turn my life around. I don't got nothing to hide. Why don't you test me? Just test me now.
Keep walking.
Keep walking. This is a joke. I got nothing to hide. I'll take any type of drug test you got.